All right. Well, welcome everyone to Estate Planning 101. I know there is no place in the world you'd rather be on a Wednesday evening than here with us talking about this topic, but it is one that is incredibly important and really near and dear to my heart. I am a certified financial planner, but one of my passions is estate and elder care planning. And the reason for that is my own experience with my father, who thankfully we were able to get his estate plan in place, have it executed before he actually suffered a major stroke. And I really understood the importance of having a plan in place before something happens, because you don't want to be scrambling when life happens and life occurs, trying to find those documents or not having anything in place at all. You really want to be prepared. So when we talk about estate planning, I found this to be interesting, but to be honest, I wasn't quite surprised. Caring.com actually does a wills and estate planning study. They do this every single year. And basically, they found that only 24% of US adults actually have a will. And that is very scary. I know during the pandemic, that number did go up because people started seeing people unfortunately pass really quickly. They also started to find that they needed other documents in order to make sure that their loved ones were taken care of. But essentially, still, that's only 24%. And there's a lot of reasons for this. A lot of it is maybe procrastination, feeling like you have insufficient assets to actually have an estate plan, which is absolutely not correct, or just not really having a clear knowledge of the estate planning process. And that is really the reason why we wanted to do this webinar. The one thing that I want everyone to take away from this webinar is that your estate plan is not the 10 Commandments. It is not set in stone. It can be changed, it can be modified, it can be updated. So please don't let that fear prevent you from doing something, because you can always make changes at any time. So throughout this webinar, we are going to kind of talk about celebrities and those who were able to really have an estate plan in place that was implemented the way it needed to be, and then those who unfortunately did not. And Prince is one that honestly shocked me, because he was so stuck on making sure that he had control of his music, making sure he had control of his rights. So it was really surprising to me when he died in 2016 intestate. And what that means is that he died without a will. So basically, the state of Minnesota had to decide how his assets were going to be distributed. And it was a very lengthy process, millions in legal fees. And essentially, he had six siblings who got a share of his assets. And from what I've read, he wasn't particularly close with all of his siblings, but because he didn't have something in place to say this is what his wishes were, they were in his bloodline, and therefore they could make a claim on his estate. And so when we talk about estate planning, it is an essential part of your overall financial plan. So we do comprehensive financial planning for all of our clients. And estate planning is really a very crucial component, because when we talk about generational wealth, how do you achieve generational wealth if you don't have a plan in place to move that wealth from one generation to the next? And so this is why it's incredibly vital. You want to make sure that your wishes are clearly documented and legally enforceable in the event of death or incapacitation. So if you don't have something in writing, it is left to the courts to decide. It is left to someone else to decide. And so that's why estate planning must be one of those things that you check off next to everything else when you're talking about getting your finances in order. And so when we talk about a trust versus will, a lot of times people feel as though it's interchangeable. They hear it and they say, well, isn't it pretty much the same thing? And it is not. There are some key differences. So a will is basically a legal document that outlines how a person wants their assets to be transferred at the time of death. Now, with a will, you have to go through the probate process. And what that means is that your executor will have a copy of your will. They will go to the county where you reside, submit that will, and that starts the process of basically having that probated and making that available to the public. So it is a public process. That means that anybody could go look up your will. Anybody can go and look up a detailed outline of your assets and liabilities. So it really leaves you open to everyone being able to view what you have going on. Now, this is very different than a trust. So a trust is really allows for your assets to be managed and distributed privately. So this is without court involvement. So it gives you a lot more control and flexibility and also potentially tax benefits. But ultimately, it allows you to not involve the court when it comes to your assets. And so that is an incredibly important point for most people. So when we talk about, having a plan in place, I know many of you, I'm sure, heard the story about Aretha Franklin. She literally had two wills. One was handwritten in 2010, the other one in 2014. One of them, I think, was found in her couch somewhere. The other one was found in a desk drawer. It was just random that people were able to even locate it. And so this became a big issue because both of these documents were vastly different when it came to how the assets were to be distributed. And I believe she had about four heirs. So that means each one gave maybe some of the heirs a little bit more versus the other. And it really became a battle. So it took really a Michigan jury to determine which will they felt like was the valid one, which ended up being the 2014 will. But just imagine how much time it took. It took 5 years for this to get settled. So that's time, that's money, that's wasted. And it also leaves a lot of bad feelings when it comes to those heirs because, I'm sure all of them feel like maybe they missed out on something. Another celebrity, Sonny Bono. I don't know how many of you know who Sonny Bono is, but he was married to Cher. They actually had a musical group together. I think it was Sonny and Cher, Cher and Sonny. He also was a politician. He was a mayor of a city in California and also a representative in the state of California. He passed away from a freak skiing accident, and really he died once again intestate. And it really opened up a lot of issues because his ex-wife wanted to stake a claim on his estate. His current wife wanted to stake a claim. He had children. So, after months, finally they were able to get it settled. But here goes someone who really had, approximately 2 million. So it wasn't a large estate, but once again, that time and money being wasted having to air this all out in the public through the court system was not really the optimal way of doing it. And so when we talk about the difference between going through probate versus having a trust, so a will versus a trust, is really more than just the fact that you may not want this to be public. You may not want your assets at the time of death to be known to everyone. It also becomes really important for people who are homeowners, people who are real estate investors who own property in different states, as well as business owners. So, for those individuals who own properties in different states, let's say maybe you have a primary home in New York and you have a vacation home in South Carolina. At the time of your death, New York may be your state where you reside, but because you have assets in other states, you would have to go through what we call ancillary probate, which means you would have to go through the probate process in each one of those states if all you had was a will or if you died intestate. So imagine the time and the cost that could go into the fact that now your executor has to go to each one of those states in order for those properties to be transferred to the heirs. So this is one of those situations where I would say definitely a revocable living trust makes sense, especially if you do have, several properties in different locations. Also, if you're a business owner for business continuity purposes, you want to make sure that even after you pass, the business continues on, or maybe it's left to family or whomever. You want to have a trust because it gives you a lot more control and flexibility. And so another thing to also think about is when you're talking about passing on assets to the next generation, you want to think about the thought of, possibly your 18, 19-year-old essentially getting a check if you was to pass away. So they're getting a check and they're getting access to your 401k, your IRA, maybe life insurance benefits. Are you really comfortable with them basically just getting that money all at one time? And so once again, this is where trust comes in, and we're going to talk about it in a second, because it really allows for you to dictate how assets are distributed, a lot more so than just a will. And another thing to also note, if you have children, whether they're minor or adult children who have special needs, you absolutely want to look at doing a trust, because that will allow for you to provide for them in their adulthood. So when we talk about creating an estate plan, I would say there are really 5 questions that you want to ask yourself before you even get started. So the first one is, who is going to receive my stuff, right? So this is essentially your beneficiaries. Like, ultimately, who's going to get what? The next one really deals with the what, when, and how. So what are your beneficiaries going to receive? When are they going to receive these assets? And then how are they going to receive them? So that is really important to think through. The next one is when we talk about incapacitation, or maybe you having an illness or injury, a financial power of attorney. So who is going to step in and be your voice if for some reason you cannot be? And this is really in managing your finances, your financial affairs. Along with that, or along those lines, we have the healthcare power of attorney. So this is who's going to make medical decisions for you if you're unable to. And then the last one is guardianship. So who is going to have legal custody of your minor children and make financial decisions for them? And this is a really crucial one, because you want to make sure that you're providing for your children, your minor children, in the event something happens to you. You want to make sure that they are going to be comfortable and settled and taken care of financially. So there are really 5 essential documents that go into any estate plan. And I'm going to briefly just mention them, and then we're going to go into more detail as we go along. So the first one is a trust. Next, we have a pour-over will, a durable power of attorney, healthcare directive, and a HIPAA authorization form. And so each one of these really goes along with making sure you have that solid estate plan. So the first one is the revocable living trust. And honestly, this is really the heart of your estate plan. So this is really like the main organ that's pumping and flowing and making sure everything works the way it needs to. It's really the foundation for making sure that you have clear directives of how your assets should be managed during your lifetime and then distributed upon your death. And so when we talk about method of distribution and we talk about maybe children, this is where you're able to say, you know what, I want to make sure that my children do receive my assets, but maybe I want to spread it out. I don't want them to get, a check at 18, or maybe not even a check at 20. Maybe I might want to do 1/3 of my assets to be distributed at 25, another 1/3 at the age of 30, and maybe the last 1/3 once they reach 35. You can decide what that looks like. It is really up to you, the individual, and also if you are a couple to decide how they want that to happen and to occur. But you have that control, and you really have that flexibility to really spell out what it is your wishes are. And I would say this is almost like I wish I had like flashing lights right now, because the most important thing when you're talking about a revocable living trust is having the trust drafted and executed is just a piece of paper. You actually have to fund the trust. And what that means is you have to retitle your assets into the name of the trust in order to make sure that the trust is the governing document for your assets when you're talking about distribution. So it's not enough just to say, oh, I created this document. I'm done. I can now go off into the sunset. I have everything done. No, there is another step, and that another step is incredibly crucial. And speaking of which, we come to Michael Jackson, right? Michael Jackson, this is someone who's, we all know who he is. He had millions and millions of dollars, so much in terms of his assets, created the Michael Jackson Family Trust. Wonderful. Unfortunately, he didn't fund the trust. And so what that meant was at the time of his death, everything had to go through probate, which made a very public process. It is still ongoing. There were, of course, a lot of infighting between the siblings, creditors, the IRS, of course, wants their piece. So it really has been a drawn out process since he passed away in 2009. So just imagine the amount of money and time that has been wasted. And when he created the trust, he created it to benefit his children and his mother. And unfortunately, because the assets are frozen, because they're going through the probate process, they essentially just get an allowance. They don't really even have access to the assets. And, that right there says it all. His wishes and what he intended for the trust is really not what is happening right now. And so, along with a revocable living trust is what we call a pour over will. And so, a pour over will is really like a safety net for assets that unintentionally are left out of the trust during your lifetime. So, it allows for those assets to basically go into the trust at the time of your death. What is important to note, and incredibly important to know, I know I keep saying that, but these are things that people need to focus on, is a pourable will is still a will. So you still have to go through probate. It doesn't prevent that process from happening because essentially those assets were not retitled into the name of the trust. And so what I tell people is for big items, or what I would say assets like property, you really want to get those assets retitled into the trust. You don't want to leave that open to possibly going through the probate process. So really make sure that you focus on those items that are bigger in nature, located in different states. That's really what you want to make sure is funded. The next one we have that is important is the durable power of attorney. This allows for someone to be your agent and really have authorization to manage your finances. And that can be everything from paying your bills, that could be managing your investments. It also could be possibly moving assets into a trust. And so you want to make sure you have this document, because if for some reason you are incapacitated, the banks are not necessarily required to give information to your spouse or your adult children or your loved ones. And so oftentimes when there's nothing there, it could lead to a legal fight. It could lead to them having to go to the court to basically petition to be appointed as your conservator or guardian. And so once again, anytime anything involves the court, it is not going to be a quick process. It is not going to be a cheap one as well. So you want to really make sure you have that documented. Along those lines is we have the Advanced Healthcare Directive and Living Will. The Advanced Healthcare Directive is basically the healthcare power of attorney. And with this is where you're able to make your wishes known of who you want your agent to be to make medical decisions for you. And that also goes into having a living will, which is very different than a will. A living will really provides for you to say what your wishes are when it comes to life sustaining measures, or if you prefer limited interventions. So, this is where we're talking about artificial life support, whether or not you want to be resuscitated. You want to really spell that out as much as you can because you don't want to leave that in the hands of your family. That's incredibly emotional for them to have to make that decision, and especially if they don't know what it is you would have wanted. So here we go again with you being able to let people know what your wishes are. The next thing that goes along with that healthcare directives is the HIPAA authorization form. So hospitals and doctors are not required, actually, they're legally not allowed to give out your medical information to your spouse or even your adult children or your loved one. So you want to make sure you have that authorization form completed so that they have access to your full medical history. So that will allow them to make an informed decision. So when we talk about, creating and establishing this plan, just actually getting it executed is just really one piece of the puzzle, right? Great, you have these documents, great, they all been executed, but really this is where you have to really have a good conversation with your beneficiaries, but also with those individuals who are going to be either the executor, the successor trustee, or the guardian. So a few more examples of people passing and having a will maybe in place, but did not update the will once a child was born. So we have Heath Ledger. He passed away in 2008. He actually did create a will in 2003. However, his daughter was born 2 years later, and he actually never updated the will to include his child. So, there was this, you know, big issue of, okay, we have this estate. He had this will. He said he wanted things to be distributed X, Y, and Z. The daughter was left out of it. However, the family collectively came together, and those individuals who were listed in his will as the beneficiary actually relinquished their rights to his estate and basically transferred their rights to his daughter. So they came together as a family and made that decision so that it wouldn't have to become this lengthy process through the court system. But, once again, that's sort of a silver lining. It may not have happened that way, but they came to that decision themselves. Now, another person who actually did have a solid estate plan in place was Kobe Bryant. And of course, he passed away unexpectedly with his daughter in 2020. His estate was massive. Kobe Bryant had a lot of different businesses, but he created a revocable trust with his wife as the co-trustee. And that trust actually just included three daughters at the time. His youngest daughter was only 7 months old at the time of his passing and was not included in the trust. So the trust provided for income and principal to be distributed to the wife as well as the children. The youngest daughter was not included, but because it was a revocable living trust and because his wife was a co-trustee, she was able to, after his passing, include the youngest daughter into that trust. So then that way she would also receive all of the benefits of the other children. So this is someone who had a solid plan in place and was able to, even in his passing, continue to make sure that his family is taken care of. And so once you have this drafted, as I mentioned before, you want to really have this conversation with the executor of your estate or the successor trustee or trustee, as well as the guardian. And you should really have these conversations with these individuals before you execute anything to make sure that they understand the role that you're asking them to serve. But once you have your documents executed, you want to make sure that it is not the best kept secret in the world. You want to make sure that people know where these documents are located and how to access them. So that can be just simply letting them know this is where you can find the documents in my home. My attorney has a copy of it. Here goes my attorney's name and information. You will be able to have access to it because you are the person who will be responsible for my estate. I would say some people like to leave their documents in a safe deposit box. The only issue with that is you want to make sure whomever the executor or trustee is going to be, that they're added to that safe deposit box and have a key to access it. Because if your name is the only name listed, they would have to go through the courts to basically get authority to even access the safe deposit box. So it almost defeats somewhat of the purpose of you going through everything that you're going through. And then you also want to have, even if it's a high level conversation, you want to have a conversation with the beneficiaries, right? You want to talk to them about what it is you were thinking when you drafted your estate plan, what is expected to happen, upon your passing. You at least don't want to leave people in the dark because that creates a lot of bad feelings, a lot of hurt possibly, and you really want to be able to articulate what your wishes are to your loved ones and to those who are going to potentially be responsible or benefit from your assets upon passing. And just to let you know, we actually are going to have two webinars coming up. One is going to focus on how to have conversations with family members when it comes to your estate plan. And the other one is helping you understand how to fund your trust. So, like I mentioned, those are two really important things, and we will be having webinars that will be focused on both topics in the future.